ladies and gentlemen of the committee, before we discuss the future of humanity, meet the chairs for Europe's AI affairs. But before sitting down, let's check the upholstering. Check it out, check it out, check it out. Before he begins,
meet Alexander Peuckert. He is a law professor at Goethe University, Frankfurt am Main. He appears to understand what law means, but he does not appear to believe that law means anything, or that it should have any consequences. Goethe University's website lists him as a co-chair of the Working Group for the Code of Practice, and he even claims responsibility for drafting the copyright-related provisions, but he cannot be responsible. He may have drafted it, but to make him responsible for its content would imply that our Frankfurt law professor holds the authority to issue law, or whatever it is this code claims to be. The EU Commission says, these guidelines are not binding for providers of general-purpose AI models. Of course not. How could it be binding? An authoritative interpretation of the AI Act may only be given by the Court of Justice of the European Union. Exactly. That's what people mean by law. An independent judiciary system. Do they know about this at Goethe University Law School? Nevertheless, these guidelines set out the Commission's interpretation and application of the AI Act, on which it will base its enforcement action. Right, but the Commission does not have enforcement action. Our Frankfurt law professor knows that. In 2024, he writes, the initial scholarly feedback on the final version of the AI Act is critical of the inclusion of copyright protection measures, as they are deemed to be incongruous with the overall subject matter and purpose of the Act. I share this critique because Article 53, number 1C and D merge two different types of laws. This implies that he thinks this is bad, so he goes on. The AI Act does not address these copyright-related challenges in a way that is typical for copyright law. It applies regulatory tools known from laws that protect public interests in a preventive, risk-based manner to private interests in the protection of a property right. If there is a model for this, it is the GDPR. So GDPR is about private data protection, like if somebody stores your email to send you stuff without having asked you if you would like to receive their stuff. He says, the difference between the GDPR and the AI Act is, however, that the GDPR forms a coherent whole, and the AI Act does not. Law cannot function without coherence. It is the idea to treat similar things the same and not different. Otherwise, it would not make a difference whether you have committed a crime or not, for deciding whether you should be in prison or not. The limited personal scope of application of Article 53 AIA potentially prejudices an effective enforcement of the copyright-related obligations, in particular as regards the moderation of generative AI output. This means no protection if the output infringes copyrights. The two copyright-related obligations set out in Article 53 reject the proposition that generative AI output is itself protected by copyright. He says, the AI Act functions as an abstract meta-regulation next to and on top of existing copyright laws. The training summary obligation cannot be derived from copyright law because it is completely independent from any claim that the training involved certain protected content. The meta-obligation is primarily useful to detect copyright infringements during the model development process. Now we are getting to the conclusion. There is, strictly speaking, no relevant union copyright law that general-purpose AI model providers have to comply with. And, according to settled case law, even a clear, precise, and unconditional provision of a directive seeking to confer rights or impose obligations on individuals cannot of itself apply in proceedings exclusively between private parties. Let me explain that, because it is very important. EU directives cannot impose obligations directly on individuals in horizontal disputes. Only vertical enforcement, for example, EU Commission against a member state, allows direct reliance on directives. Many policy actors, especially in tech and AI, treat Commission guidance or proposals as if they were binding law. They are not. In private disputes, even if based on EU origin law, the claim must be grounded in national implementation. National copyright law cannot be changed by this code. The EU Commission confirms that. These guidelines focus on the scope of the obligations for providers of general-purpose AI models laid down in the AI Act. They solely concern the AI Act and are not applicable to other union laws, including on liability. The code has no legal consequence. That is what this means. How can a law professor be part of such nonsense? The AI Act is a big theater performance of what law could look like. But it's not real. It has no legal effect. It's wasting everybody's time.